recording this session, so I'll upload the recording to HLMS later. All right, so all these sessions are being recorded, okay, and they will be uploaded to HLMS. So you can always go through it when you're free. All right, so all of these sessions are being recorded, and what I call that, you can always view it in HLMS. Okay. Now you see, though there are 7 sources of law, these 7 sources can be grouped into 2 categories. Okay, now there are some sources which are written. Now, example of written laws. Example of written laws are constitution, legislation, and subsidiary legislation. This refers to written law. Now, where unwritten law is concerned, okay, they are case law, English common law, and judicial precedent. Sorry, case law, English common law, and custom. So please take note, there are some sources which are written, there are some sources which are not written. Example of written laws are like constitution, legislation, and subsidiary legislation. Example of unwritten are like case law, English common law, and custom. Okay. Okay. Okay, now let's look at written law. Written law. Now, whenever you talk about written law, written law means, okay, sources of law that fall within this category. These sources of law, okay, they have been formally made by some lawmaking body or by a person who has been given power to make laws by this person. So when I talk about written law, it means these laws are officially made by some law-making body. Now, example of a law-making body is Parliament. Okay, so these laws are formally made by some law-making body, i.e. Parliament, or someone whom Parliament has given power to this person to make laws. These laws have been codified and consolidated, which means that these laws are organized and arranged properly. These laws are organized and arranged properly. Okay, so for example, now we have constitution, legislation, and subsidiary legislation. These laws are organized and arranged properly. Okay, these laws are formally made by some lawmaking body. Those are written law. Now, if you look at unwritten law means these laws are not consolidated, these laws are not codified, which means that these laws are not organized and not arranged properly. Okay, these laws are not formally made. Okay, these laws are not formally made. So example over here is like English common law, okay, case law, and also custom. All right. Now, where Muslim laws are concerned, I'm not putting them under any category. Okay, where Muslim laws are concerned, I'm not putting them under any category. Okay. Okay, now let's look at each source of law one by one. Now let's look at each source of law one by one in order to understand better. All right? Number one, Constitution. Constitution. Okay, now what is Constitution? Now please take note, nearly all countries on this planet have a constitution. So what is a constitution? Okay, now any country, okay, any given country, in any given country, any laws which they feel is very, very important, they'll put it in the constitution. Alright? So in a given country, any laws which they feel is very, very important, they'll put it in the constitution. So what kind of laws can you find in the constitution? In the constitution, you can find the most important laws in the country. So the most important laws in the country, they'll put it in the constitution. So in the constitution, you can find the most important laws in the country. Now the issue here is, what kind of laws can you find in the constitution? Now, it very much depends on the country. It very much depends on the country. Different countries may find different laws to be important. Okay? So, but having said that, okay, most countries, they have laws pertaining to human rights in the constitution. Most countries, they have laws pertaining to human rights in the constitution. For example now, freedom of movement, freedom of speech, freedom of choosing your religion. These kind of laws you can find in the constitution in most countries. Okay? Most countries, any country. Okay, I'm sure in your country also it's the same thing. Alright? So even in the US, yes. Okay, even in Malaysia also yes. Even in Singapore also yes. Even Australia also yes. Okay? So anyway, in Malaysia, okay, we have one constitution. Okay? And this is the strongest law in the country. Strongest law. Okay? So please take note, the constitution is the supreme law of the land. Supreme law here means it is the strongest law. It is the strongest law in the country. Okay? And it can only be changed if you can obtain a two-thirds majority of the total number of members in parliament. Okay? Now in Malaysia at the moment, okay, in parliament, okay, we have 222 members. In Malaysia, in parliament, there are 222 members. So to change the constitution, you must have at least the approval of 148 members. Only then you can change the constitution. Okay, in Malaysia, okay, currently in parliament, we have 222 members. So therefore, to change the constitution, you must get approval of 148 members. Okay? By the way, the slides are already in HLMS. You can download them. Alright, the slides are already in HLMS. You can download the slides from there. Okay? Okay, now the next issue here is what is the content of the constitution? Okay, now in Malaysia, in the constitution, it lays down the powers of the federal and state government. Okay, in Malaysia, in the constitution, they do lay down the powers of the federal and state government. There are laws pertaining to human rights. Okay, it talks about the national language of Malaysia. Okay, the national language of Malaysia is actually Malay. Alright, but English is widely spoken. And of course, how to become a citizen of the country. How to become a citizen of the country. Talk about laws pertaining to that. Okay. Okay, next. All right, next. Please take note. Article 4, Clause 1 states, okay, that the Constitution is the strongest law in Malaysia. Now, you see, the laws in the Constitution, we call them articles. Okay, so the laws in the Constitution, we call them articles. So you have Article 1, Article 2, Article 3, Article 4, they are called articles. Okay, so Article 4, Clause 1 says that the federal constitution is the strongest law in the country. Okay. Now, what I call that? What does that mean? Okay. So, if there's any law which is inconsistent with the constitution, we follow the constitution. All right. So, the constitution is the strongest law in Malaysia. So, therefore, if there's any law which is inconsistent with the constitution, we follow the constitution. Okay. Alright, so like for example in this case, it was decided that these two laws were inconsistent with the federal constitution and therefore these two laws were made void. Okay, just an example, no big deal about this. Okay. Okay, now next, legislation. Okay, now please take note, constitution. Okay, where constitution is concerned, constitution is made by parliament. Legislation is also made by parliament. Then the question over here is, what's the difference between the constitution and legislation? Alright, so where parliament is concerned, parliament makes the constitution. Parliament also makes legislation. Then, what's the difference between this? Now, please take note, where the constitution is concerned, okay, constitution, we only have one. We only have one constitution. Okay, and this is the most important law in the country. Okay, and to change the constitution, you can only do so if you can obtain a two-thirds majority in parliament. So please take note, constitution we only have one. Okay, now all other laws apart from the constitution which is made by parliament is called legislation. So legislation is a normal law. Legislation is a normal law made by parliament. So constitution, we only have one. All other laws, apart from the constitution, which is made by parliament, is called legislation. So legislation is a normal law. Okay? And to make a legislation, okay, you only require a simple majority. Now, do you all know what is a simple majority? Simple majority means you must get the approval of at least 50% plus 1 members of parliament. 50% plus 1 members of parliament. Okay, that's my information. Now, where legislation is concerned, legislation, it always ends with the word ACT. Legislation always ends with the word ACT. For example, now we have Contracts Act 1950. We have Contracts Act 1950. Hire Purchase Act 1967. Alright, so it always ends with the word ACT. It always ends with the word ACT, Act. Okay? Which one? Yeah. It's an example. Yes, you're correct. Okay, shall we continue? Can I? Let me erase this. Erase. Okay, now legislation is also known as statute. It is also known as an act of parliament. Okay, now, where legislation is concerned, legislation are laws, okay, which are made by parliament. Alright, so these are laws made by parliament. Okay? So these are laws which are made for a particular purpose. It can be any laws. These are actually normal laws. Normal laws. These are actually normal laws. Okay? Legislation here means made. The word legislation means made. These are laws made by parliament. Okay, these are laws made by parliament. Alright, that's for information. Okay, now let's look at how laws are made in Malaysia. Okay, now all laws, they start as a bill. Okay, all laws, they start as a bill. A bill is a proposed law. A bill is a proposed law. Okay, now the bill will go to parliament. The bill will go to parliament. Now, in Malaysia, like any other given country, parliament consists of two houses. Okay, one is the lower house. The lower house is called, in Malaysia, the lower house is called Dewan Rakyat. This is the lower house. It's called Dewan Rakyat. And to become a member of the lower house, you have to stand for elections. To become a member of the lower house, you have to stand for elections. Elections are held once in 5 years. The elections are held once in 5 years. Okay, and currently there are 222 members. And just for information over here, the political party that wins the most seats over here will form the government. Okay, the political party that wins the most seats in the lower house will form the government. Okay. Now the second house is called the upper house. The second house is called the upper house. The upper house is also known as Senate. The upper house is also known as Senate. Okay, in Malaysia, the upper house is known as Dewan Negara. Okay, the upper house is known as Dewan Negara. Okay, now to become a member of the upper house, you will be chosen. You will be chosen by the king, you will be chosen by the state. Okay, and currently we have 70 members. And each member, his term is for 3 years. Alright? So a bill will go to Parliament. Parliament says yes. Then the bill will go to the king. The king says yes. Then the bill becomes an act. Act here means it becomes a law. It becomes a law. So these are how laws are made in Malaysia in a very simplified way. Alright? A bill is a proposed law. The bill will go to Parliament. Parliament says yes. It will go to the king. King says yes. It becomes an act. It becomes an act means it becomes a law. Alright? So in a very simplified way, these are how laws are made. Okay? Yes. Proposed law. Let me write another nicely. Okay? Alright, can I erase this? Can I? Okay, so this one refers to the king. Alright, this one refers to the king. This is actually the king. Okay? Yang di-Pertuan Agong. Malaysian loves long names. Alright, so the king is actually Yang di-Pertuan Agong. Alright, alright. Alright. Let's continue. A bill is a proposed law, like what I mentioned here just now. There are 3 types of bills. One is proposed by the government, we call it a public bill. One is proposed by somebody who is not from the government, we call it a private bill. And a hybrid bill is it is a bill which is proposed both by the government and by an outsider. All right, just for information, not so important now. Okay. Okay, next, subsidiary legislation. Subsidiary legislation. Now, where subsidiary legislation is concerned, this is also known as delegated legislation. This is also known as delegated legislation. Over here, Parliament gives power to someone to make laws. All right? Alright, so subsidiary legislation means Parliament gives power to someone to make laws. So how does it work? How does it work? Okay? Now, please take note. Sometimes Parliament will make a law. Sometimes Parliament will make a law. But the laws which are made by Parliament, sometimes they are not detailed. They are not comprehensive. They are not good enough to govern day-to-day matters. The issue here is, why are laws made by Parliament not detailed, not comprehensive, not good enough to govern day-to-day matters? Okay, there are two reasons for it. Number one, Parliament doesn't have time. Parliament doesn't have time to look into every detail of the law. Okay? Because Parliament only meets a few times a year. And number two, Parliament doesn't have the expertise. You see, members of Parliament, they do come from a diverse background. You cannot expect them to be experts in all areas. So Parliament will make a general law, and then Parliament will then give power to someone or somebody to make detailed laws. This someone or somebody could be the minister. Okay, it could be a government department. It could be a government ministry. It could be anybody for that matter. And when this person makes detailed laws, we call it subsidiary legislation. And these laws are detailed, these laws are comprehensive, and these laws are good enough to govern day-to-day matters. Now, one way to know that they are subsidiary legislation is that these laws, they always end with the word rules. These laws, they always end with the word guidelines. These laws always end with the word regulation. These laws always end with the word bylaw. So whenever you come across any laws that end with these words, these are actually subsidiary legislation. Whenever you come across any laws that ends with these words, they are actually subsidiary legislation. Okay? All right, shall we continue? Can I? All right, all done already. Done already. So as I mentioned here before, subsidiarization here means Parliament gives power to somebody to make laws. All right, and this somebody over here could be a local council, minister, or even a professional bodies. Now, one example over here is in 2016, Parliament made this law, Companies Act 2016. And based on this law, they came up with this subsidiary legislation called Companies Regulations 2017. You see that this word regulation? The word regulation here indicates that it is a subsidiary legislation. Okay? Now, the next issue here is, why are these laws important? Now, these laws are important because these laws are very, very flexible in the sense that they can be made very, very quickly. They can be made very, very quickly. Now, if you remember, during the COVID-19 pandemic, okay, the cases of COVID-19, they were increasing like crazy. You know, so the government had to make laws quickly to solve this problem. So this is where subsidiary legislation came into play. So a lot of subsidiary legislations were made in order to solve the problem of COVID-19. That was back in the year 2020. All right. So subsidiary legislation, they can be made very quickly. They can be removed very quickly. That's why they are very, very flexible. Number two, these laws are very, very detailed. Okay, they are very, very detailed. They are good enough to govern day-to-day matters. And number three, these laws are made by experts. These laws are made by experts. People who know that area very, very well. People who know that area very, very well. Okay? Alright, now this is the last one. Okay, this is the last one over here. What are the limitations of subsidiary legislation? Now, the first limitation over here is, okay, you see, when Parliament makes a law, okay, and they give power to somebody to make subsidiary legislation, okay, they'll tell the person what he can and what he cannot do. So in other words, okay, what they call that? So when Parliament gives power to somebody to make subsidiary legislation, Parliament will tell the person what he can and what he cannot do when he makes subsidiary legislation. All right. So in other words, Parliament supervises the making of subsidiary legislation. So when Parliament gives power to somebody to make subsidiary legislation, Parliament will tell this person what he can and what he cannot do when he makes subsidiary legislation. Okay? And number two, we do have the doctrine of ultra vires. Ultra vires here means doing something you are not supposed to do. All right, so please take note. When somebody makes subsidiary legislation, this subsidiary legislation, okay, it cannot contradict. When somebody makes subsidiary legislation, the subsidiary legislation cannot contradict any laws which are made by Parliament. If it does, then according to the doctrine of ultra vires, such a law is null and void. Okay? So, the doctrine of ultra vires here means doing something you're not supposed to do. So what it basically means is that when somebody makes subsidiary legislation, this subsidiary legislation cannot contradict any laws which are made by Parliament. If it does, then according to the doctrine of ultra vires, such a law is void. It doesn't exist. Okay? It doesn't exist. from this chapter, you only need to know up to this. For this chapter, you only need to know up to this. Alright, so you only need to know what they call constitution, legislation, and subsidiary legislation. Nothing beyond this. Nothing beyond this. Alright, so are there any questions? Okay, no questions. Let's take a 10 minutes break. I'll see you all in 10 minutes time. We'll look at some questions. Alright, so let's take a 10 minutes break.
Yeah.
Miss Pregnant sent DDMA.
Yeah.
Yeah, she says go back to the hotel.
Yeah. Once we have, I think we'll dismiss the class about.
Alright guys, if you're ready, look at some tutorial questions now. Okay, there are about 8 questions over here. I just want you to read through these questions and we'll do it together in a short while. Okay, so there are 8 questions now. I'll give you about 5 minutes to read through these questions. Try to understand, try to figure out the answer, and then we will do it together. Now, in your midterm exam, okay, you could be given questions like this, okay, and these are questions will carry about 20 marks. But don't worry too much about how much you need to write. Your answer can be as much as maybe 3/4 of a page or 1 page should be enough. 20 marks does not mean that you need to write more than 1 page, not beyond that. I mean, it depends on the size of your handwriting. If your handwriting is small, maybe even half a page is enough. Alright? If your handwriting is big, maybe 1 page. Alright? So I give you 5 minutes to read through the questions, try to understand, and then we'll do it together in about 5 minutes time. Alright?
uh, 3/4 page expression.
Yeah, half a page to 3/4 page. Huh?
Alright guys, we are ready, shall we start? Okay. Oops. first question over here. Explain any 6 sources of law in Malaysia. Now, when you're given a question like this, okay, what you need to do over here is your job is to identify the 6 sources and explain these 6 sources in about a page. Alright? So what you can do is, remember the 6 sources of law are number 1, constitution, number 2, legislation, number 3, subsidiary legislation, case law, English common law, custom and Muslim laws. What you can do is you can choose any 6. You can choose any 6 and explain in about less than a page. Alright, so about 2 or 3 lines, try to explain what you understand by constitution. In about 2 or 3 lines, explain what you understand by legislation. The same thing for the rest of it. Alright? So you can choose any 6 and explain in about a page. Are you okay with this? Okay, what method you choose to write, I leave it to you all. Okay, but I prefer if you write it in paragraphs. That means one paragraph, one short, maybe 2 or 3 lines about constitution, 2 or 3 lines about legislation, something like that would be easier. Okay? Okay, shall we? Next question. In your opinion, which is the more important source of law? Okay, give reasons for your answer. Okay, so in your opinion, which is the more important source of law? Of course, it is written law. It is written law. Alright, it is written law over here. Alright, so what you can do over here is you can say that what do you call that? The most important source of law is actually constitution. Okay, why? Because all the most important laws can be found in the constitution. Okay, it's the most important source of law because it consists of laws made by Parliament, which is the highest lawmaking body in Malaysia. And the next one over here is the constitution, which is part of written law, which according to Article 4, Clause 1 is the supreme law of the land. And furthermore, there's extra protection given to the constitution. Okay, to make any changes to the constitution, a two-thirds majority is required in Parliament. Alright? So if the question asks you, which is the most important source of law in Malaysia? The answer is constitution. Alright? And in about maybe half a page or 3/4 of a page, explain why you say the constitution is the most important source of law. Okay? Okay, can we continue? Can? All right, so let's go to the next question. Okay, now explain the differences between constitution and legislation. What are the differences over here? Okay, now just for information over here, okay, constitution, okay, when we talk about constitution, okay, this is the most important laws are put in the constitution. And to change a constitution, you need a two-third majority, okay, and you can also say that there's only one. Is only one constitution. There's only one constitution. Now, where legislation is concerned, these are normal laws made by parliament. And to change it, you require a simple majority. All right, and we can say that there are so many legislations. There are so many legislations. Okay, so these are some of the differences you can talk about. Okay, these are some of the differences you can talk about over here. All right. All right. Shall we continue? Okay, now let's look at question number 4. What is subsidiary legislation? What is subsidiary legislation? Now, as I mentioned here before earlier, okay, where subsidiary legislation is concerned, these are laws which are made by someone or somebody whom Parliament has given power to that person to make these laws. Okay, so in other words, Parliament gives power to someone to make laws. The person whom Parliament can give his power could be the minister, a government department or government agency or the federal bank. Alright? Now these laws, they normally end with either rules, regulation, guidelines or bylaws. So this is a short explanation of what we mean by subsidiary legislation. Are you okay with this? Alright, guys, we are ready. Shall we continue? Look at question number 5 next. Alright. Where question number 5 is concerned, unfortunately the answer comes out first before the question. That's very bad. Anyway, why is subsidiary legislation important? Now, subsidiary legislation is important because number 1, it is flexible. Why? It can easily be made, it can easily be removed. Number 2, these laws are very, very detailed. And number 3, these laws are made by experts. Okay? Alright, so we are done with this. Refer to question number 6. Alright, now, what are the differences between written and unwritten law? Now, as I mentioned to you all earlier, where written law is concerned, written law refers to those laws which are consolidated and codified, which means that these laws are organized and arranged properly. Okay? These laws are formally made by some law-making body or by a person to whom power has been given to make such laws. Example of written laws are like Federal Constitution, Contracts, and Syllabus Act. Now, where unwritten law is concerned, these laws are not consolidated, these laws are not codified. These laws are not formally made. Okay? Example over here are like English common law, judicial precedent, and custom. Okay? Okay, if you're done with this, okay, I want you to refer to the next question. Alright, now, give 2 reasons why, okay, written law is a more important source of law compared to unwritten law. Now, I already mentioned here before, there are 2 reasons for this. Number 1, okay, written law consists of those laws which are made by Parliament. And what is Parliament? Parliament is the highest lawmaking body in Malaysia. Alright? And number 2, the Federal Constitution is part of written law, which according to Article 4, Clause 1, is the supreme law of the land. Supreme here means these laws are the most important laws in Malaysia. Okay? Alright, now this is the last question next. This is the next last question. Explain the content of a constitution. What should the constitution, what does the constitution consist of? Now please take note, the content of the constitution are, number one, it lays down the powers of the federal government and the state government. It talks about human rights. It talks about the national language. It talks about how to become a citizen of the country. Okay, these are examples of it. These are just examples of the constitution. Okay. All right, now with this, we have finished with the first part of our revision. Okay, there'll be one question from this area in the exam. One question, all right? One question that carries about 20 marks. Just take note of it. So it can be either on constitution or maybe legislation or maybe subsidiary legislation. Okay, one of it. Okay? Alright, so we'll discuss this. Alright, now we will look at the next part. Not this one. This one. Yep. Okay, let me. Okay, next. All right, now next is the revision number 2, i.e. Malaysian Legal System 2, and there will be 2 questions in the exam from this chapter. Okay, now one question will be an essay question. Essay question is like what we have done just now, a straightforward question. And a second question over here could be a problem question. Problem question over here means I'll give you a scenario and your job is to find out what's the problem and advise accordingly. Advise accordingly. Okay? So where this chapter is concerned, there will be 2 questions in the exam. Alright, one will be an essay question and the other one will be a problem question. Take note of it. Alright, shall we start? Okay, now the first thing I want you to know over here is I want you to know the differences between civil and criminal law. Okay, now where criminal law is concerned, please take note we only have one criminal law. Alright, we only have one criminal law. And criminal law, it concerns offenses against the state. What do you mean by offenses? Offenses here means things which you cannot do. For example, now, you cannot steal. Stealing is an offense. Alright? You cannot hit somebody. Hitting somebody is an offense. You cannot murder somebody. Murder is an offense. Alright? So, criminal law, it concerns offenses against the state. Okay? Now, where civil law is concerned, now please take note, we only have one criminal law. Everything else is civil law. Everything else is civil law. For example, now, contract, law of contract is civil law. Company law is civil law. Okay? Copyright, trademark, patent, family law. All these are civil laws. All of these are civil laws. Okay? Now, civil law is a dispute between private individuals. dispute between private individuals. So for example now, I sell you my car, I give you my car, but you don't make payment. I sell you my car, I give you my car, but you don't make payment. Because you did not make payment, there is a dispute between you and me. There is a problem between you and me. I sell you my car, I give you my car, but you don't make payment. Because you did not make payment, there is a dispute between you and me. Next, what is the purpose of criminal law? Now, the purpose of criminal law is to preserve order. The purpose of criminal law is to preserve order. Now, order here means peace. You want peace in the country. You want harmony in the country. Alright? So how do you preserve peace in the country? You preserve peace by the country by punishing those people who break the law, with the hope that others will not do the same thing. So the purpose of criminal law is by punishing those people who break the law, with the hope that others will not do the same thing. Now, civil law, the purpose is to remedy the wrong. Remedy here means correct the wrong. So for example now, I sell you my car, I give you my car, but you don't make payment. So because you have not make payment, there is something wrong in this transaction. You did not make payment. So I'll sue you for payment. I'll sue you to correct the wrong. What's the wrong? You did not make payment. Okay? Now, the parties who are involved in a criminal case is the prosecutor. The prosecutor is the government lawyer. Alright, it's a government lawyer. It's more like lawyer representing the state, not actually the government lawyer. It's actually the lawyer representing the state. Okay? And the defendant is a person who broke the law. Alright, so so the parties who are involved in a criminal case are the prosecutor. The prosecutor represents the state. The state, that means the authorities, okay? And sometimes we call it the government lawyer. Sometimes we tend to call him the government lawyer, okay? Technically, they're not government lawyers now, alright? But we are tend to calling them government lawyers now, okay? Now, the defendant is the person who broke the law. Now, under civil cases, if I am suing you, I'm the plaintiff. Who are you? The defendant. Alright, the defendant. Alright, this information. Okay, next. How much do you need to prove to win the case? How much needs to be proven in order to win the case? Now, where criminal law is concerned, the standard is very much higher. Alright? Now, in order for the prosecution to win the case, in order for the defendant to be punished, okay, the prosecution must prove their case beyond a reasonable doubt. Now, beyond a reasonable doubt basically means the judge must be more than 90% convinced that the defendant broke the law. Only then the defendant can be punished. Alright? So in other words, the prosecution must bring evidence. They must bring enough evidence to convince the judge more than 90% that the defendant broke the law. Only then he'll be punished. Now, where civil law is concerned, the standard is a bit lower. Where civil law is concerned, in order for the plaintiff to win the case, he must prove the case on the balance of probabilities. That means, the plaintiff must convince the judge, okay, more than 50% that whatever he's saying is the truth, then he can win the case. Alright? If you be more precise like that lah. Okay, that means the plaintiff must bring enough evidence to convince the judge more than 50% that whatever he is saying is the truth, then he can win the case. Okay? Now please take note, under criminal law, okay, if the person is guilty, he will be convicted. If he's convicted, he will be punished. Under civil law, if the person is innocent, he will be acquitted. If he's acquitted, he will be freed. He will be freed. Okay? Now, under civil law, the person is either liable or not liable. The person is either liable or not liable. Now, example of criminal laws are like imprisonment. Imprisonment is like jail sentence lah. Jail sentence. Fine. Fine is a monetary punishment. Okay. Under civil law, we have damages, injunctions, special performance, rescission. We'll study this under law of contract later on. Okay. Example of criminal law is like murder, theft, drunken driving, things like that. Civil law is like contract, tort, trust, property law, and whatnot. Okay. All right, shall we continue? All right. Next is alternative methods of dispute resolution. Now, you see here, whenever you face a legal problem, okay, now the first option available to you is to sue the person in a normal court. All right. So, whenever you're having some legal problem, the first option available to you is to sue the person in a normal court. Now, the problem with normal court is that normal courts, number one, they are very, very expensive. Okay, they are expensive because you need to engage a lawyer, you need to get a lawyer, and then the entire process is very expensive. Number two, there could be delays. You have to wait for your turn for the case to be heard. Number three, there is no privacy. There's no privacy because the normal court, they operate on an open court system. The normal court, they operate in a normal court system, which means that anybody can go and listen to the case. Anyone. It's open to everybody. So the disadvantage over here is that, okay, everybody may know what's your problem. Everybody may know why you're suing. So sometimes that can be embarrassing. Sometimes you don't want people to know why you're suing the person. You want the matter to be settled quietly. Okay? So that's why sometimes instead of suing somebody in a normal court, it has been suggested that you should consider alternative methods of dispute resolution. Alternative methods of dispute resolution here means other ways to solve a problem. Okay, so alternative methods of dispute resolution here means other ways which are available to solve a problem. Okay, now these are other ways available to solve a problem. These are other ways available to solve a problem. Number one, negotiation. Number two, mediation, or we call it conciliation. Number three, tribunal. And number four, arbitration. Okay, so these are other ways available to solve a problem. Are you okay with this? Are there any questions? Okay. Now let's look at it one by one. Let's look at it one by one. Okay? Now, the first one over here is negotiation. The first one over here is negotiation. Now, where negotiation is concerned, what it basically means is that if I have a problem with you, negotiation here means I try to talk to you to solve the problem. That means we talk in order to solve the problem. So negotiation here means both parties who are having a problem, they try to talk to each other to solve the problem. Okay? It is very, very informal. Very, very informal. There is no third party involved. If you want, you can engage a lawyer. If you want, you can ask a lawyer to help you. Okay, if you want, you can ask a lawyer to help you. Okay? Now, negotiation is a process where both parties try to solve the problem on their own. Both parties try to solve the problem on their own by talking to each other. By talking to each other. Okay? So this is the cheapest way to solve a problem. It is very, very private. Outsiders will never know what's going on. Outsiders will never know what is going on, and there is complete privacy. Alright, there is complete confidentiality. Alright, outsiders will never know what's going on because you try to solve the problem quietly on your own. Okay? Are there any questions? Alright guys, let's take a 10 minutes break. Alright, we'll continue in about 10 minutes time. Alright, so let's take a 10 minutes break.
use lawyer to apply.
Can. We can use the lawyer.
Alright guys, shall we continue? Okay, now the second way how you can solve a dispute is by mediation. Now, where mediation is concerned, okay, what you do is you ask a neutral third party. You ask a neutral third party to help you solve the problem you're having with another person. So, for example, now, okay, if you and I are having a problem, we can ask a friend of ours to help us solve the problem. Okay? Now, a mediator's job is not to give a solution. His job is to recommend or help both parties reach a settlement. Alright? So, where mediation is concerned, okay, a mediator is somebody who helps two people reach a settlement. Okay? So, for example, now, if you and I are having a problem, we can ask him to become a mediator. His job is to convince both of us to reach a solution. Okay? He will not be making any decision. He will only be recommending, helping both of us reach a settlement. Okay? So, mediation and conciliation is the same thing. It's the same thing at the end of the day. Alright? It is a situation where parties try to solve a dispute with the assistance of a neutral third party. Okay? The purpose over here is this guy will suggest help both parties reach a compromise. Okay? The mediator's job is to consult both parties and help them reach a settlement. Okay? Now, mediation is very commonly used in various places. Now, mediation is also used in divorce cases in Malaysia. So, for example, now a husband and wife, they want to get a divorce. So the law may require them to go through mediation first. Alright? This is called marriage counseling. This is called marriage counseling. The marriage counselor's job is to talk to the husband and wife and try to convince them not to get a divorce. Alright? The neutral third party acts as a facilitator. This is a very cheap way to settle a dispute. There is complete privacy. Outsiders will never know what is going on. Okay? And mediation is also is used under employment law, family law, and even under consumer disputes. Okay? Just for information now. Next, tribunal. Now, you see, where tribunals are concerned, okay, tribunal is similar to a normal court. There is a judge over here who will listen to arguments from both parties. And after he listens to arguments from both parties, okay, he'll make a decision. And both parties must follow the decision. So under tribunal over here, there is a judge. Okay, the judge over here, he will listen to arguments from both parties. And once he listens to arguments from both parties, he'll make a decision. And whatever decision he makes, both parties must follow. Now, where tribunals are concerned, okay, we do have domestic tribunals. Domestic tribunals are in-house tribunals. Alright, so like sometimes certain clubs, they may have some tribunals. Okay, but our concern is not domestic tribunals. Our concern over here is statutory tribunals. Now, statutory tribunals, okay, these are tribunals created by Parliament. In order to help, in order to reduce the burden of the normal courts. Alright? So over here, statutory tribunals are tribunals created by Parliament in order to reduce the burden of the normal courts. These are actually specialized courts. They are actually specialized courts. They only hear certain matters. They only hear certain type of matters. They don't hear all the matters. They only hear certain type of cases. Okay? So, where tribunals are concerned, okay, we don't have tribunals in all areas. We only have tribunals in certain areas. We only have tribunals in certain areas. For example, now, we do have a consumer tribunal. So as a consumer, if you have any problems, you can go to the consumer claim tribunal. We also have an industrial court. Industrial court, they listen to employment matters. So if the employer and employee, they're having some dispute, they can go to the industrial court to try to solve the dispute. Okay? We are not concerned about domestic tribunal. We are not concerned about domestic tribunal. Okay, we don't care about domestic tribunal. We're focusing on statutory tribunal. Okay. Okay, now here are some advantages of tribunals. Number one, they have specialized personnel. That means the judges are experts in the area of dispute. Okay, so over here when we talk about specialized personnel, we are talking about judges. We're talking about judges. The judges here are experts in the area of dispute. The judges here are experts in the area of dispute. They only hear that kind of matters. So, for example, now, if you're talking about consumer claim tribunal, the judge there, he only hear consumer matters and nothing else. So, he's an expert in the area of dispute. Number two, this is a cheaper way to solve a problem. Why? Because you cannot engage a lawyer. No lawyers are allowed here. So you save money in that sense. The entire process is cheaper. The entire process is cheaper. And the dispute can be settled quickly. The dispute can be settled fast. Why? Not many cases here. There are not many cases which are heard over here. So, in this sense, okay, the dispute can be settled faster. Okay? Next, it's more informal. So it is actually an easier process. Easier process because it's more informal. Okay, the rules of evidence, they are relaxed. Okay, to put in evidence and whatnot is easier. And the objective over here is to reduce the workload of the normal courts. And also, you can always appeal to the normal court. If you're not happy with the decision made by a tribunal, you can always appeal to the normal courts. Okay? And there is privacy. There is privacy. They operate in a closed system. They operate in a closed system. That means outsiders are not allowed to go in and listen to the case. Okay? Now, are there any questions? All right, now we are finished with tribunals, and let's look at the last one over here, which is called arbitration. The last one over here is called arbitration. Okay. Okay, now if you look at arbitration, arbitration is something like a normal court. It is similar to a normal court. It is similar to a normal court. Okay? Over here, there is a judge. The judge over here is called an arbitrator. Okay, the judge over here is called an arbitrator. The judge over here is called an arbitrator. The judge's job over here is to listen to arguments from both parties. After he has listened to arguments from both parties, okay, he'll make a decision, and both parties must follow that decision. Okay? Now, in Malaysia, we do have an arbitration center called the ASEAN International Arbitration Center. Okay? And the law that governs arbitration is called the Arbitration Act 2005. And this is based on the international law called the Unilateral Arbitration Rules of 1976. Okay? So as I mentioned here before over here, arbitration is something like a normal court. Okay? Where arbitration is concerned, it is similar to a normal court. Litigation here means normal court. This is normal court. Then what's the difference over here? Arbitration is a private court. Arbitration is a private court. That means over here, where arbitration is concerned, okay, you choose your own judge. Okay, you decide where you want the case to be heard. Okay, and what they call that, you pay for the entire cost. So in that sense over here, it's a private thingy, it's a private thingy. Unlike the normal courts, they are paid by the government, they are paid by the state. Alright? The judges are employed by the state in a normal court. Okay? So in that sense, you don't have to pay for anything. So the difference between arbitration and normal court over here is that arbitration, it doesn't wield the judicial authority of the state. What does that mean? You see, if you sue somebody in a normal court, and you win the case, the other person, he must follow the decision made by the judge. If he doesn't follow, he can be cited for contempt of court, which means that the person can be jailed, he can be fined. However, arbitration is different. When you win a case in arbitration, okay, you do not wield the judicial authority of the state. If the other person refuses to follow the decision made by the arbitrator, the only thing you can do is sue the person for breach of contract for not following the decision. Okay? Now, the good thing about arbitration is that you choose your own arbitrator, which means you choose your own judge. You choose your own judge. First advantage. You decide what language you want the case to be heard. Do you want the case to be heard in English? Do you want the case to be heard in French? Okay, do you want the case to be heard in Mandarin? You decide. Okay? Even the place where you want the case to be heard, you decide. Okay? Now, where arbitration is concerned, normally arbitration is a very expensive process. Arbitration is a very expensive process, and it is used by companies, big companies. Alright, so when two large corporations, okay, if they have any problem, they'll refer the matter to arbitration because it's a very expensive process. So when two large corporations, when they enter into a contract, sometimes in the contract itself, they will put an arbitration clause. Arbitration clause here means they will put a term in the contract that says that if there's any problem in the future, they will refer the matter to arbitration. So for example now, two companies, they enter into a contract to do something. In the contract itself, it is stated that if they have any problems in the future, they'll refer the matter to arbitration. Even if you don't have an arbitration clause in the contract, the moment two parties have a problem, okay, they can, if they can agree in writing, if they agree in writing that they want the matter to be decided through arbitration, then you can go through arbitration. Alright? So there are two ways how you can go to arbitration. Number one, when two parties initially enter into a contract to do something, in the contract itself it is stated that if there's any problem in the future, they refer the matter to arbitration. Even if you don't have this, okay, the moment a problem arises, if both parties agree in writing that they want the matter to be solved through arbitration, they can go through arbitration. Okay? So by arbitration, the decision made by an arbitrator is called an award. Okay, decision made by an arbitrator is called an award, and this decision is binding. Both parties must follow the decision. Okay, now after the arbitrator makes a decision, if you want, you can go to the normal court and ask the normal court to confirm the decision. This way, you can get the judicial authority of the state, which means that if the parties don't follow this decision, okay, they can be cited for contempt of court. Now, arbitration is more expensive than going to the normal court. It's a very expensive process because you have to pay for everything. So normally, only big companies go to arbitration. They only go to arbitration if the dispute involves millions of dollars, millions and millions of dollars, okay? And you can use a lawyer. All right, a lawyer can be used over here, okay? Now, advantages of arbitration. Number one, the dispute can be settled faster. The dispute can be settled faster, number one. There is privacy. Outsiders will never know what is going on. And how formal you want depends on the parties. How formal you want the case to be depends on the parties. If you want it to be very, very formal, can. If you want it to be informal, also can. Up to you. Okay? Alright, now here are some advantages of arbitration. Number one, you can choose your own arbitrator. It's more informal. There is complete privacy. There is complete privacy. Outsiders will never know what's going on. Okay, there's more privacy. And the decision, the award is a decision. The award can be enforced by the normal courts. Okay, the awards can be enforced by the normal courts. Disadvantages are you will have to pay the entire cost. You have to pay the entire cost. It's more expensive. It's more expensive. You have to pay for the entire cost. Okay, and you can't appeal. The decision made by the arbitrator is final. You cannot appeal. You see, if you go to the normal court, you are allowed to appeal twice. Okay, if you go to the normal court, you're allowed to appeal twice. Okay, but arbitration is different. The decision made by the arbitrator is final. You're not allowed to appeal. You're not allowed to appeal. Okay. Now, the last one over here is statutory interpretation. Basically, what it means is that sometimes, if you refer to a legislation, there could be a word in the legislation that doesn't make sense. Alright? So in this kind of situation, what can you do? So even a judge, when he's referring to a law or a legislation, there could be a word or few words that doesn't make sense. What can he do? So over here, there are a few things he can do over here. Alright, so this is known as rules of interpretation. Now the first thing what a judge can do is, whenever the judge is making a decision, and if he's having any problem, what he can do is he can use the literal rule. Literal rule here means, okay, the judge will give a direct translation to the word that does not make sense. And this can be done by referring to a dictionary. Alright, this can be done by referring to a dictionary. Alright, so if there is a word in the Act of Parliament that doesn't make sense, what a judge can do is, okay, he can give a direct translation to the word that doesn't make sense. And this can be done by referring to a dictionary. Okay? Now, the second thing what the judge can do is, if there is a word that doesn't make sense, the judge can use the golden rule. Under the golden rule, okay, what the judge will do is, the judge will give his own interpretation to the word that does not make sense. Alright? So under the golden rule, okay, if there is a word that doesn't make sense, the judge can give his own interpretation to that particular word that does not make sense. That means he gives his own meaning. And the meaning he gives over here could be different from the meaning you find in the dictionary. Okay? Mischief rule. Now, under the mischief rule, okay, what a judge will do is, in order to understand the law, the judge will see what problem Parliament was trying to solve when they made this law. Alright? So where the mischief rule is concerned, okay, if there's a law that doesn't make sense, what the judge will do is, the judge will try to find out what problem Parliament was trying to solve when they came up with this law. By doing this, he'll be able to understand what the law is all about. Okay? Generis rule. Now, according to the Justum Generis rule, it says that if in the law, okay, there is a specific word followed by another specific word, and ends with a general word. Then, in order to understand the meaning of the general word, the meaning of the general word must be confined to the meaning of the specific word. So, if in the Act of Parliament, okay, if there is a specific word followed by another specific word and ends with the general word, in order to understand the meaning of the general word, the meaning of the general word must be confined to the meaning of the specific word. So, for example, now, okay, if you look at this Act of Parliament, in this case over here, Powell and Kempton Racehorse. Okay, if you look at this case over here, Powell and Kempton was racehorse over here. Now, in this case, what happened was there is a law that stated gambling is not allowed in any room. Room is a specific word. We know what a room is. Okay? It is not allowed in an office. Office is a specific word. We know what office is. Okay? And any other place. Any other place is a general word. That means it is too wide. We do not know what it is. It is too wide. It's too big. Anything can amount to other place. Therefore, in order to understand the meaning of other place, the meaning of this word must be confined to the meaning of these two words. Now, if you look at room, room is indoor. Some place which is indoor. Office, we know it is some place which is indoor. So therefore, any other place should be any other indoor places. Alright, any other indoor places. Alright, so this is what you mean by just the generalist rule. Okay, so if there is a specific word followed by another specific word and ends with a general word, in order to understand the meaning of the general word, the meaning of the general word must be confined to the meaning of the specific word. Okay, just take note of it. Are you okay with this? Are there any questions? Okay, now, Malaysian legal system 2, there'll be 2 questions in the exam. Okay, there'll be 2 questions in the exam. So, there'll be 1 simple essay question and there will be 1 problem question. Okay, so it's a short chapter, Okay, nothing much you need to know. Okay, it's not so difficult, it's quite simple. Alright, so what we'll do is, we can go for early lunch now. Okay, and we can continue at 1 o'clock. We can continue at 1 o'clock, and in the afternoon we can look at some questions from this area, as well as we can look at offer and acceptance. Alright, and tomorrow we'll look at some questions on offer and acceptance, and we also will look at consideration tomorrow. Okay? So are there any questions? No questions? Let's go for early lunch, and I'll see you all at 1 o'clock. Okay, I'll see you at 1 o'clock. Thank you so much.